Okay, so this is chapter 4 in the 11th edition textbook, and this is part 2. And we're talking about the Commerce Clause, which appears in Article 1, Section 8 of the U.S. Constitution, and empowers Congress to regulate commerce within foreign nations and among the several states and with Indian tribes. Okay, now, I like to spend some time on the Commerce Clause because I think it's probably one of the most interesting and topical areas that we have. And here's the reason why. Okay, historically, the Commerce Clause was interpreted very narrowly so that you had a very narrow application to laws that Congress passed and whether they were constitutional or not under the Commerce Clause. And that was that they had to have a direct effect on interstate commerce. That is, things that pass in commerce from one state to another. But many, many years ago, that historical interpretation by the Supreme Court was overturned by the Supreme Court, and a much more broad application came across and allows for indirect effect on interstate commerce. And we'll see that in some of the slides in a minute. The end result of that, though, is what we have today, and that is a federal legislative body, Congress, that has a broad powers to make laws that affect all the states. Without those powers, we would be a very different looking country. And we'll see some of the cases that probably illustrate that. So you might see, for example, if you didn't have that power, you might see things like Social Security go away, Obamacare, things like that. Okay, so all right, so there's the old law in 1824 that I talked about. Then in 1942 and thereafter, the Supreme Court broadened that rule. And an example of that that I was earmarking earlier is this Heart of Atlanta Motel versus U.S. And if I remember the facts of this case correctly, this was a hotel that had a policy of segregation of blacks and whites, and it was under the federal discriminatory laws. It was held to be violative of those laws, and the hotel couldn't do that. And it was challenged by the hotel on the basis that the federal government didn't have the power to do that under the Commerce Clause. And based upon the standards that were enacted beginning around 1942 with the Wickard case, the Supreme Court said no, that is within the power. And the facts of the case, if I recall correctly, were that it was the restaurant in the Heart of Atlanta Motel that was involved, and the issue was that everything that they bought for the restaurant and all the people that worked for it were all within the state of Georgia. And so they argued that there was no effect on interstate commerce. But the Supreme Court said no, there's an indirect effect because if you segregate, you're not going to get customers from out of state. Your products there's something always in those products that has some interstate effect, etc. So that's basically it. Okay, so today the Commerce Clause authorizes the national government to regulate virtually any business enterprise, including those that are internet-based. Okay, so one of the things I wanted to point out, and I said at the beginning that this is one of the areas that interests me. The reason it interests me is because it's an example of a conflict in the central government versus the local government that's existed from the beginning of time and continues to exist. And that is that there are still a significant number of people who think that the Commerce Clause is over broad in its application and interpretation. And so there's been an attempt over the last 20, 30 years to get the Supreme Court to either reverse that Wickard case, go back to an older standard, or at least to cut back on it. And there's been a few cases where we've seen that sort of happen, where the court has drawn the line. Okay, and so the breadth of the clause permits the national government to legislate in areas in which Congress has not explicitly granted power. An example of that is the federal government to regulate non-commercial activities relating to medical marijuana that takes place wholly within a state's borders. So that's an interesting area. The thing with marijuana that you have to keep in mind is that states that have legalized marijuana either for medical purposes or for recreational purposes, it's still a crime at the federal level. Why are people not getting arrested? Simply because the federal government, through the executive branch, in a check and balance type of situation, has decided not to enforce those laws, at least the time being. Okay, so we see that there. All right, the Dormant Commerce Clause is an issue about, well, if federal government has the right to make laws involving interstate commerce, what's the right of the states to regulate commerce within the states, intrastate, and where that might conflict with what the federal government is doing? So in those situations, the Supreme Court has ruled that courts have to balance the state's interest against the burden that the regulation places on interstate commerce in deciding whether that law that was passed that deals specifically or limited to intrastate activity and conflicts with a federal law passes this test. Generally, states that enacted pursuant to the state's police power are presumed to be valid. If the state law substantially interferes with interstate commerce, it's likely to be held unconstitutional. Okay, so here's a case involving that dormant clause, and you can see an explanation of that. Okay, the power of Congress to tax comes from Article 1, Section 8. Congress has the power to lay and collect taxes, duties, imposts, and excises, which shall be uniform among the states. Now, it's real interesting. I want to diverge for a second, but a good example of some of what we've been just talking about is Obamacare. Obamacare was challenged in court as being violative of Congress's authority under the Commerce Clause and under the power to tax. So almost every legal scholar focused on the Commerce Clause because, as I said, that's still kind of a hot issue. It went up before the United States Supreme Court, and it was really interesting because 4 judges said that it was within the authority of Congress to pass the Obamacare under the Interstate Commerce Clause, and 4 said that it was not. That's 4 versus 4. There's one more vote. That was the Chief Justice Roberts. So Chief Justice Roberts said, well, maybe not. It's not under the Commerce Clause, but it is within the taxing power because it's a taxing law. So essentially, Obamacare was upheld as being constitutional, but with a plurality. That is, you had 4 justices saying the Congress had the power under the Commerce Clause, the Chief Justice saying it had the power under the taxing laws. So that's an interesting application of where Congress gets its authority. All right, so you can look at the taxing and spending as it is under this slide as well. Don't want to spend too much more time there. All right, so we're going to stop there with Part 2. We'll pick up with Part 3. The magic word for Chapter 4 is Constitution. And we're going to pick up with the Bill of Rights.